Paragraph 1 of Article 294, Robbery with Homicide. This is a special complex crime, punished as a single crime, although robbery and homicide are committed by the offender. Meaning of homicide. The term homicide, as used in paragraph 1 of Article 294, is to be understood in its generic sense as to include parricide and murder. The juridical concept of robbery with homicide does not limit the taking of life to one single victim or to ordinary homicide. The juridical concept of robbery with homicide does not limit the taking of life to one single victim, making the slaying of human beings in excess of that number punishable as separate, independent offenses. All the homicides or murders are merged in the composite, integrated whole that is robbery with homicide, so long as all the killings were perpetrated by reason or occasion of robbery. There is no special complex crime of robbery in band with double homicide and or less serious or slight physical injuries under the present code. If robbery with homicide or with other crimes enumerated above is committed by a band, the indictable offense would still be robbery with homicide under Article 294, Paragraph 1. But the circumstance that it was committed by a band is an element of the crime, but is not an element of the crime, but is merely a generic aggravating circumstance, which may be offset by mitigating circumstances. The homicides or murders and physical injuries, irrespective of the numbers, committed on occasion or by reason of the robbery, are merged in the composite crime of robbery with homicide. Robbery with homicide absorbed the physical injuries. Where injuries were committed apart from robbery and homicide, the crime is only robbery with homicide, physical injuries being absorbed by the former. There is no such crime as robbery with murder. Treachery cannot be considered as qualifying circumstance of murder because crime charged is a special crime of robbery with homicide. The treachery which attended the commission of the crime must be considered not qualifying, but merely as aggravating circumstance. Generic aggravating circumstance. Robbery with homicide in dwelling does not require that robbery with force upon things is first committed. Is it necessary that a robbery has taken place first and the homicide is committed on an occasion or by reason thereof? No, it's not required. What makes the crime robbery with violence against person is the injuring or killing of a person on occasion or by reason of the taking of the personal property belonging to another with intent to gain. Thus, when the culprits first ask for permission to enter the house and ask for food from the victims in the house, and when already inside they began to massacre the victims, the entrance is not with force upon things, but when they had the intention to take personal property in the house, which was the reason for killing the victim, and in fact took away personal property, they committed robbery with homicide. Robbery with homicide need not be committed inside a building. Thus, the culprits who killed the victim on the street to get, as in fact they got, the latter's personal belongings are guilty of robbery with homicide. In order for the crime of robbery and robbery with homicide to exist, it is necessary that it be clearly established that a robbery has actually taken place and that as a consequence or on the occasion of such robbery, a homicide is committed. With due respect, the statement is not accurate. What does that mean? An intent to take personal property belonging to another with intent to gain must precede the killing. If the idea of taking the personal property of another with intent to gain came to the mind of the offender after he had killed the victim, he is guilty of two separate crimes of homicide or murder, as the case may be, and theft. This is the ruling in the case of People versus Atanasio, and People versus Elizaga, and People versus Glore. The crime of robbery with homicide, even if the motive of the offender was that of robbery as well as revenge. But when the intent to commit robbery preceded the taking of human life, it is immaterial that the offenders had also a desire to avenge grievances against the persons killed. They are liable for the special complex crime of robbery with homicide. Homicide may precede robbery or may occur after robbery. Killing first the victim and then afterwards taking the money from the body of the deceased is robbery with homicide. But if the offender have intent to take personal property before, but the offender must have intent to take the personal property before the killing. killing the victim after taking him out to sea several hours after the robbery was committed in another place, it's still robbery with homicide. Take note that by reason, the term by reason covers homicide committed before or after the taking of personal property of another, so long as the motive of the offender in killing the person before the robbery is to deprive the victim of his or her personal property, which is sought to be accomplished by eliminating an obstacle or opposition, or in killing a person after robbery to do away with the witness or to defend the possession of the stolen property. It is immaterial that the death of the person supervened by mere accident, provided that the homicide be produced by reason or on the occasion of robbery, inasmuch as it is only the result, without reference or distinction as to the circumstances, causes, modes, or persons intervening in the commission of the crime, that has to be taken into consideration. Thus, in the case of People versus Giapar, it was held that the death of the guard resulting from the injury he sustained during the robbery qualifies the offense to robbery with homicide. As long as homicide resulted there during or because of the robbery, even if killing is mere accident, robbery with homicide is committed. Homicide to eliminate an obstacle to the commission of robbery. One of the accused asked the deceased for money, threatening to shoot him if he would refuse. The deceased replied that he had no money, and as he turned his back, he started to go home. He was fired upon by two of the accused. After shooting him down, the accused went to the house of the deceased, threatened his wife there, took their trunk, broke it open, and took their farm 400 pesos. As the killing and the robbery were not committed in the same place, the accused contended that crime committed cannot be robbery with homicide. Ruling: the accused had the intention of robbing the deceased when they asked him for money, and they shot him to eliminate an obstacle to the effectuation of their unlawful design, which was shown by the fact that they repaired to his house, which was nearby, and by force took his money therefrom. There is direct connection between the killing and the robbery. Homicide committed to remove opposition or to suppress evidence. When all the four homicides were perpetrated with the sole end in view of removing the opposition to the robbery or suppressing the evidence thereof, it is robbery with homicide. Cases decided by the Supreme Court of Spain. A priest was robbed of the money which he carried with him at the time and tied to a tree. One of the robbers feared that he was recognized by the priest, turned back, and killed him. It was held that the crime was robbery with homicide. One of the robbers returned to the place where the robbery had been committed for the purpose of closing the gate from a corral from which the cattle had been stolen, in order that the remaining cattle might not get out. He was seen by the man in charge of the cattle, who, up to that time, had not noticed any of the cattle had been stolen. He upbraided the robber, and the latter assaulted and killed him. It was held that the killing was independent of the robbery, because the man was not killed to do away with the witness. He was killed because he upbraided the robber. Homicide necessary to defend possession of stolen goods. When the accused were coming out of the store and were carrying away stolen goods, the deceased stopped and attacked them. 2 or 3 of the offenders returned the attack and killed the deceased. Ruling: robbery with homicide. The homicide was committed to defend the possession of the stolen property. Killing a person to escape after the commission of robbery is robbery with homicide. Pacifico Gardon, Catalino Astillero, Amador Iltis, and Antonio Rodrigo were accused of robbery and banned with homicide and serious physical injuries. While the robbery was going on, the bell of the local chapel began to ring as if giving a general alarm. Alarmed and fearful of their safety, the robbers attempted to escape at the back door, but they found it closed. When the door of the store was opened, and finding a chance to escape, Altis and Rodrigo hurriedly came out through that door towards the beach, followed later by their companions Gardon and Astillero. While Gardon was trying to escape, he met on the way Ingracio Manga and Emilio Fuentes, who went to the store because of the general alarm, and upon seeing Fuentes, immediately stabbed him on the abdomen, causing his instantaneous death. The defense contends that the robbery was committed independent of the crime of homicide, for the reason that the plan preconceived by the appellants was merely confined to the commission of robbery and did not include that of homicide. But this contention evidently is unsustainable, for it cannot be denied that the killing of Fuentes took place practically in the course, if not as necessary consequence, of the commission of robbery. Said action be therefore considered as constituting a special crime of robbery with homicide. Is it robbery with homicide if the person killed is the robber himself? It would seem that it's still robbery with homicide if in the course of the robbery another robber is killed by his companion who wanted to get a lion's share of the loot. The law does not require that the person killed is the owner of the property taken. The opening sentence of Article 294 says, any person guilty of robbery with the use of violence against any person. Paragraph 1 says, when by reason or on occasion of the robbery the crime of homicide shall have been committed. The killing of any person by reason or on occasion of the robbery should be punished with the highest penalty regardless of the person killed. There is robbery with homicide even if the person killed was an innocent bystander and not the person robbed. The law does not require that the crime of robbery be also the victim of homicide. It is robbery with homicide even if the victim of a person supervened. It is robbery with homicide even if the death of a person supervened by mere accident. The case of People versus Mangolabnan et al. Facts of the case. Defendant removed the iron bar from the door leading to the balcony, and after opening the said door, two persons whose identities were not ascertained entered. One of the two unidentified marauders searched the person of Monica Del Mundo and took from her 200 pesos in cash and a gold necklace valued at 200 pesos. But not contented with the loot, the same individual asked Monica Del Mundo to give her diamond ring, which the latter could not produce, and for this reason struck her twice on the face with the butt of his gun. One of the small children of Vicente Pacson, who was terrified, called his mother and that unidentified person, irked by the boy's imprudence, made a move to strike him, but Monica Del Mundo warded off the blow with her right arm. At this juncture, the second unidentified individual put his companion aside and, climbing on the table, fired his gun at the ceiling. Afterwards, the defendant and his two unidentified companions left the place. After they were gone, Cipriana Tadeo called her husband Vicente Pacson, and receiving no answer, she climbed the ceiling and found him lying face down, already dead. Ruling. It may be argued that the killing of Vicente Pacson was an unprecedented act that surged on the spur of the moment, and possibly without any idea that Vicente Pacson was hiding therein. That the English version of Article 294, Paragraph 1 of the RPC, which defines a special, single, and indivisible crime of robbery with homicide, states that it is committed when by reason or on occasion of the robbery the crime of homicide shall have been committed, but this English version is a poor translation of the prevailing Spanish text of the said paragraph, which reads as follows. Con la pena de reclusión perpetua a muerte cuando con motivo o con ocasión del robo resultare homicidio. We see, therefore, that in order to determine the existence of the crime of robbery with homicide, it is enough that the homicide resulted by reason or on occasion of the robbery. Where homicide and physical injuries were perpetrated to remove the opposition of robbery or superseding evidence thereof, the crime is robbery with homicide only. Physical injuries inflicted upon Prudencio Tizon as well as the killing of Filomena Tizon should be merged in the composite integrated whole that is robbery with homicide. It is evident that the killing and physical injuries were perpetrated with the sole end in view of removing opposition to the robbery, of suppressing evidence thereof, or both. When homicide is not proved, the crime is only robbery. Thus, if the victim, after having been deprived of his personal property with intimidation while in a bangka, was dumped overboard and thereafter was never seen or heard, the fact of his death is not sufficiently established because he might have survived by swimming to the bank of the river. In this case, the accused is liable only for robbery because there is no sufficient evidence to prove the homicide. When robbery is not proved, the crime is only homicide. When the prosecution fails to show that robbery was committed, there is no evidence that certain personal property was taken by the accused. The latter should be convicted of double homicides if two persons were killed by the culprits. Outside of the confessions, no sufficient evidence stands to prove that anything was stolen from the house of the victims. Others' testimony that the victim had money 4 or 5 days before the incident, hiatus between the reception of money and the delict itself was long enough for the deceased to send money elsewhere. Without separate proof of corpus delicti, the extrajudicial confession will not support conviction for robbery. Since robbery was not proved, conviction for robbery with homicide becomes impossible. In robbery with homicide, must a person charged as accessory have knowledge of the commission, not only of robbery but also of homicide? In People versus Doble, it was held that where the accomplices knew merely that a gang which took them as bangka drivers would stage a robbery and they were left at the beach by the gangmen, the fact that the latter killed several people in escaping will not make them liable as accomplices. So, dili liable ang katong bangka drivers. Their complexity must accordingly be limited to the robbery, not with the killing. Having been left in the bangka, they could not have tried to prevent the killings as it is required, one of them seeking relief from liability of assault committed during the robbery. Similarly, it was held that the most that could be found against Pedro Bernardo is that he knew of the robbery only, not of the killing. He knew that the money turned over to him for safekeeping was a product of robbery. He should therefore be held as accessory only of simple robbery, not of the grave offense of robbery with homicide. Take note that Article 53 provides that the penalty to be imposed upon the accessory to the commission of the consummated felony is a penalty lowered by 2 degrees and that prescribed by law for the 2 degrees than that prescribed by law for the consummated felony. If the consummated felony is robbery with homicide, there is no legal basis for imposing upon the accessory penalty from the accessory the penalty lower by 2 degrees than that prescribed for robbery only. Robbery cannot be separated from homicide because they are merged in the composite integrated whole, the special complex crime of robbery with homicide punishable with one penalty. All who participated in the robbery as principals are principals in robbery with homicide. When homicide is committed by reason or on occasion of robbery, all of those who took part as principals in the robbery should also be held liable as principals of the single and indivisible felony of robbery with homicide, although they did not actually take part in the killing, unless it clearly appears that they endeavored to prevent the same. Robbery with homicide distinguished from highway robbery. The trial court erred in convicting the accused of the crime of highway robbery with homicide. To be sure, the crime accused appellant committed was robbery with homicide, not highway robbery as defined in PD 532. Conviction of highway robbery requires proof that several accused were organized for the purpose of committing it indiscriminately. In the case of Barr, there is no proof that accused appellant and Johnny organized themselves to commit highway robbery. The prosecution established only a single act of robbery as against a particular person. This is not what is contemplated in PD 523, the objective of which is to deter and punish lawless elements who commit acts of depredation upon persons and properties of innocent and defenseless individuals who travel from one place to another, thereby disturbing the peace and tranquility of the nation and stunning the economic and social progress of the people. Consequently, accused appellant should be held liable for the special complex crime of robbery with homicide. Under Article 294 of the RPC, when homicide is committed by reason or on occasion of robbery, the penalty to be imposed is reclusion perpetua to death.